In June 2010, SSNIT started a $34 million OBS project to use information and communications technology ICT to revamp its operations to enable it to provide a state-of-the-art pension administration system in the country. It is the case of the prosecution that between September 2013 and September 2016, the 5 accused persons, that is, the former SSNIT boss, Mr. Ernest Thompson, a former information technology IT manager at SSNIT, Mr. John Hagan Mensah, the Chief Executive Officer of Perfect Business Systems, PBS, Ms. Juliet Hassana Kramer, a former head of Management Information Systems, MIS at SSNIT, Mr. Caleb Kweku Afaglo, and the lawyer for SSNIT, Mr. Peter Haibor, engaged in various illegalities that caused financial loss to the state in relation to the said project. The contract sum, the prosecution said, was bloated from $34 million to over $66 million, even though the OBS system failed to perform efficiently as the project contract had envisaged. They had pledged not guilty to the charges, and trial is yet to start at the Accra High Court. Mr. Ernest Thompson wants the charges against him struck out on grounds that the prosecution failed to provide adequate particulars of the offences as required by law. On every charge sheet, there is a statement of offence which states the particular offence an accused person has been charged with, and the particulars of offence which provide the details of what an accused person is alleged to have committed in relation to the offence, and this case was not different. And Mr. Thompson argued that the prosecution failed to provide sufficient particulars on the offences levelled against him as required under Article 19(2) of the 1992 Constitution and Section 122 of the Criminal Offences Procedure Act 1960, Act 30. His lawyers argued that the particulars are so scanty that they do not afford their client any concrete information to enable him to mount his defense. The prosecution, on the other hand, has insisted that the particulars of the offences contain adequate information and argued that the contention of Mr. Thompson, if allowed, will amount to prosecution providing evidence in the particulars of offence. The offences levelled against him, Mr. Thompson, and the other accused persons include willfully causing financial loss to the state, conspiracy to commit the crime, defrauding by false pretense in contravention of the Public Procurement Act, and authoring of forged documents. The former SSNIT boss first filed an application before the trial court to protest the action by prosecution, but it was dismissed on April 19, 2019. Dissatisfied with the decision, Mr. Thompson appealed to the Court of Appeal on the grounds that the High Court committed an error of law and also erred by dismissing his application. The application was granted by the appeal court. The state, opposing the ruling of the Court of Appeal, went to the Supreme Court to have it reversed, but the Apex Court on Thursday, March 17, 2021, affirmed the ruling of the Court of Appeal, stating that the application by the state had no merit and therefore dismissed, saying,